Welcome to Business 105, 101, and Law 105. We are finishing up Module 1, so just continuing to review the structure of the court system and how cases go through. So what you really should be taking away from this chart and the next one is that it's a three-tiered system. Every case starts at the bottom tier, which is trial court, and then they move up, and then they move up. So by the time something has gotten to the Supreme Court, it's already been to trial court, with a jury, with the presentation of evidence, witnesses, and then it's gone to an appellate court, and then it's gone to the Supreme Court. So you can also think of this as like a wedding cake. I think we talked about the size of the layers, and how many cases there are at each layer. So millions of cases at trial court. Anybody can file a trial court case. But the trick for the top two layers, of course, is it is exclusive, right? It's an exclusive piece of cake. Not everyone can get one. So you have to ask for permission from the court to have an appellate and to have a Supreme Court case, and they have to agree. So at the appellate layer in California, and I don't know the exact number, it's like 7,000-ish, something like that, cases a year, from millions to 7,000. And then at the Supreme Court layer, it might have been this class if someone Googled it. I think we figured out they had 83 or 80, something like that, so California Supreme Court cases last year. So you can see it is just so tiny. So very few cases are given an appeal. Awesome. So it was one. I know someone looked it up. It was 83. And so that really, and it's similar on the federal system. So that really helps you understand, how rare it is to go from one tier to the next. So anybody can file a court case, can file a lawsuit in trial court. But then to go to the next two levels, it really is up to the courts looking at your case and seeing that there was a problem and being interested in examining it further. So what I have here, because I know some of your experience is different, is just a couple images of what typical trial court looks like. And I always remind students, if you've watched any TV shows or movies or even news or those documentaries, you have seen trial court cases. It's the jury, it's the judge, it's the witnesses, taking the stand, it's dramatic, it's members of the public watching it. So you've seen that probably a million times. One of the cool things because of coronavirus, if you're trying to think of like what's positive here, is that the Orange County Courts, Superior Court System, is live streaming all of their courtrooms that are publicly open. So remember, our court system is open to the public, except in times where they would seal it, which might be for a juvenile case or something of that nature. But they're open to the public. So normally you could walk into the courtroom, and I've had students do this, and you could go observe a court case. And let me just look at the question. So are appeals more expensive? They can be. It's hard to say if it's more expensive because you could also have an extremely expensive trial court case. But yes, it is a process, and whereas a trial court might take, to have your trial, the trial itself might only be a week long, but the process to get there might have been 6 months to a year. The appellate court case might only last a couple hours, but the process to get there might be a year and a half or 2 years. So it is sort of, I think that's probably right. It probably is a bit more expensive. It often represents what you hear, deep pockets, the ability to really finance and hang on, right? Whether you are trying to fight a judgment against you or you're trying to really get them to pay you, can be exhausting, and you really have to have the resources to hang on for that. So yeah, it might get more expensive because it's just different pieces, and it probably will take at least as long as the whole process took, if not even longer, depending on. Good question. But again, so the Orange County Courthouse, Superior Court System, is live streaming everything, since you can't walk into the courthouse and just go sit and watch a proceeding. They've got a live streams. So if you click on this link, you can then go to different departments and see what's going on. And that's really cool, really neat opportunity that normally you'd have to drive down there and find parking, and maybe you could do it, maybe you couldn't do it, do you have childcare? But now you can just observe. So I recommend you guys do that. So you can check out that link. I do have a little, I'm not going to play this for you guys right now, but it's just a little YouTube clip of a trial court. That guy is the witness, he's testifying. There's obviously the judge. This is the court reporter. off camera are the attorneys and things like that. I think we watched this last week a little bit. So this is the Ninth Circuit Court of Appeals. Circuit Court of Appeals has a YouTube channel where they also will live stream and stream the recordings of the oral arguments. So really neat, because normally that's, again, you'd have to physically go to the court to see that. They've been doing this for several years now, but really cool to be able to see that. So you can really see the difference. I think we played this last week, but I'm not sure. You guys, maybe yes or no, did we watch any of the appellate? Did we watch this Ninth Circuit link last week? Yes or no? Did you already fall asleep? Oh, okay. A bunch of people are saying no. Okay, awesome. You know what? So let's play this for a second, because I really want you to see how different this is, because most of your experience has been with like seeing trial court from the movies and different things like that. So a couple things to keep in mind. Appellate court is not meant for a lay person. Trial court really is meant, you're trying to convince a group of jurors, a lay group of jurors with no specialized training. So anyone should be able to understand the case you're presenting. Okay? At appellate court, you are only trying to convince the panel of judges. There's no jury, there's no presentation of evidence. It is simply about the legal issues involved with the trial court. Did the trial court make a mistake of law? That's all you're focused on. There's no presentation of evidence. There's no witnesses. It's just one attorney making an argument, a persuasive argument to these judges, and then the other attorney stands up and makes an argument. And the whole time they are peppered with questions. So one of the things I want you to be really aware of and notice is that this is high level. They're not trying to explain something and like bring people along. They're jumping in, and in some cases you're going to hear them mention like 5-6 cases in a row, 2 statutes, a legal standard, and they're just all boom, 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 because they're talking to experts basically. So they're having this conversation almost between expert colleagues. So they're not trying to bring us up to speed. So it can be a little strange to like plop down and watch one of these, because it's like, wait a minute, what's going on? So this case, as far as I can tell, is about, I think it's at the Nike warehouse or Nike factory, and it's dealing with what we call wage and hour law. And specifically, did people miss their meal breaks? Were they late for their rest breaks? And if they were late, were they late by 30 seconds? And if they were late by 30 seconds, is that a violation? Like if someone is late clocking out for lunch, or for their break by even under a minute, is that a violation? Does that affect the company? So I'm going to play this and I'll kind of stop and go a few times. Let me, hold on, let me make this big for you guys. I've got so many windows, not windows, but so many little things on my screen here. Okay.
May I ask you, since the Rodriguez case and the Chavez's case are virtually identical.
Now, I want you to realize what has happened. This attorney is walking up to begin the legal argument, and the judges, so that's the 3 judges, right? Obviously sitting up there. The 3 judges are immediately already asking him questions. Like he hasn't even completely walked all the way up to the stand yet. And they're already like, let's get something out here.
Identical in terms of the legal issues, maybe some slightly different facts. Or would you gentlemen be agreeable if we just kind of meld the 2 together, and we give you more time, but hopefully we can shorten the time, because other than some minor details, it seems to be a common issue. Do you agree with that?
I agree with that, Your Honors.
Okay, let's do that then. So let's assume then that let's start off with 15 minutes. If we need more time, we'll do it. I don't think we're going to need that, but let's start with that, okay?
Thank you. Good morning, Your Honors. My name is Max Gavron. May it please the Court. I represent Isaac Rodriguez and the certified class in this appeal from the District Court's order granting summary judgment. At the time the District Court granted summary judgment, there was a certified question from the Ninth Circuit pending before the California Supreme Court. Defendant at the District Court in our case moved for summary judgment solely on the grounds of the federal de minimis doctrine.
This is so in the weeds, right? You know, if you don't know the area of law, I mean, they've just put out like 3 or 4 different legal issues that, you know, is going on here. So, I mean, we're just, you know, that this is high level.
The certified question in front of the California Supreme Court in Trosser versus Starbucks asked whether the federal de minimis doctrine applies to claims brought under the California Labor Code. The district court in our case was well aware of that pending question, acknowledged it in its order, but decided to proceed to the merits. And in doing so, it granted summary judgment against our clients solely on the basis of the federal de minimis doctrine, citing in various
Okay, so there's a lot going on here. I'm just gonna, let me see if I can forward it a little bit and give you guys a flavor of some more
We
of
need
it.
a more specific finding. It's hard to believe the district court literally meant 0 seconds, but maybe a very few seconds. But but several minutes on something that can happen several times a day would be something different. Yes.
Absolutely, Your Honor. And I would direct the court in the Chavez case now. The district court there specifically looked to the expert evidence we submitted by Dr. Kriegler, and he came to a conclusion that the exit inspector.
Okay, so I'm just gonna forward it a little bit so you guys can see the other attorney and appreciate both of their hair.
Vast majority of exits take less than 1 minute. Even crediting the Kriegler report, the report from plaintiff's expert, there is no evidence to rebut Crandall's study's conclusion that many exits took 0 seconds. Exit inspections lasting more than 60 seconds were not regular.
So from your perspective, you're asking us to, if you will, construe Trosser as meaning that the minimum threshold is 1 minute. Is that correct?
I'm asking that you construe the Trosser threshold based on the facts of our case, which show that none of the exit.
Okay, so I'm gonna stop it there. But I mean, can you already see how this is really different from a trial? My Alexa app. Does that make sense how this is very different from a jury and lay witnesses and trying to explain it to people? You know, you're only speaking to judges here. So I've just found from many times students have never seen what an appellate argument looks like. So it's cool to show you guys this. And then if you're super cool or super nerdy, you can go to the Ninth Circuit YouTube page. And really fun, let's see here, you can, let me sort this by most views. Any rate, so you can go most popular, because, you know, like all the big Trump cases that have happened have been, right, you know, so you've got Washington State versus Donald Trump, you know, 145,000 views. So you can look at some of the more famous cases, any rate, which is kind of cool. And they've also got like a little informational, but yeah, just really neat. And you can enjoy this, but it's really cool. And then if you go home, I think, yeah, so right, live now. I don't know, you guys. Oh, hold on, let's see, just for fun, let's see what they're doing right now. Let me pause. So I've got a link here, and you can, you know, go to the Ninth Circuit page from the link and watch it anytime you want. The next thing I have is the Supreme Court of California also does something similar. And I don't think they broadcast everything. Oh, please don't autoplay me. Yes, there's lots of like informative and some different things, judicial council meetings, but what I have in the slides here is a link to one of their, again, oral arguments. So now we're at that top layer, the Supreme Court of California. The similar at the federal level is the Supreme Court of the United States, and the Supreme Court of the United States does not allow a video feed. The only thing they allow is an audio feed. So you can listen to live audio streams of the Supreme Court of the United States, but there is not a video feed for those oral arguments. So I'll just play this for a second. So again, this is just the lawyer only arguing, making their persuasive argument to the judges, or we call them justices, because they're at the highest level, to the justices of the Supreme Court of California. There are 7 justices for the Supreme Court of California, but one of them was not here that day because she had a death in the family. So there will be 6, but you can see how they're dealing now with all these justices. And I'll play this. I think this is like a in the weeds case about financial services and the ethics involved of like financial manager or something like that. But it's more just, I want you to kind of see the style, see how different it is. There's no witnesses, there's no jury. There's a little more people kind of in the gallery watching, but I'm just gonna forward it a
The
little bit.
question of informed consent and well. And in that situation, I think you also have to look at what was said. And so what I mean by that is if the engagement agreement between Shepard Mullen and JM says, for example, we may currently or in the future or in the past represent or have represented someone, anyone, including any of also has an advance, an advance waiver provision. You could, consistent with what's being waived.
Do you have to give notice?
It depends again on what the provision in the advance waiver provides. But the whole point of an advance waiver, for example, if a client is agreeing that in the future I may be able to represent someone adverse to you, they're always going to say, and they said here in both instances, unrelated, and as long as it doesn't involve
Could you
confidential
represent an
information.
entity that was going to sue the dormant claim?
That's what if you
So obviously the audio track is a little bit not synced perfectly with the video, but what I want you to see is it's the judges, the justices who are peppering questions to the attorney for each side. There's not an attorney asking questions of a witness because it's not a factual determination. Remember when we went back, right? Oops, I'm going the wrong way on my slide. Are you seasick yet? When we talk about moving from one layer to another in the system, the key here is made at this jump, and appeal is based on law or legal error. So trial court is really the blend of fact, and the law. But when you get to these 2 layers, it's all about law only, okay? So down here, the trial court, they will be considering, the issues of facts and law. Was the light red? Was the light green? Did the surgeon mess up your shoulder or did they do a correct surgery, right? That's a factual question that the jury would make. And if there's no jury, it would be the judge. But the jury would answer that factual question. Are you responsible for running the person over, or were they, darting out into traffic or something, or did you do everything right? Factually, they will resolve those conflicts. And then when you talk about those top 2 layers, it's now simply based on law. And at the end result, law and facts get really tied up together, but they're really looking at, was the right legal standard used? Is this the right legal standard? Do we need a new standard? Did the trial court do it correctly? Or is there something, a much finer point that we can shine some light on? So to understand that there's almost like the bottom layer and then the top 2 are a little more linked because they're both going to be focused on law. And I think when you watch, the way the arguments are, you can also understand, that how different they are. So that's kind of cool. Questions on some of that so far? Is this helpful to watch those videos? Like, let's see here. Keep going. So I don't know. Yeah, was that helpful to watch some of that? What number are we at? Like, I don't know. Drop a 5 if that was helpful to see the appellate court arguments. And then if you're totally confused, just drop a question. Oh, lots of 5s. Okay, you're probably like, I'm good, I'm Gucci, move on. So let's keep going here. Oops, what am I doing? Okay, so then what we have, and I can't remember if we went over this already, so if we did, feel free to tell me and we'll move on. But this is our map of the California court system. So I'm not sure if we went over this. If we did, let me know. If not, I'll just keep going. So we are right here in Orange County, okay? And this is obviously the map of California, and this is the 59 counties of California, I think. And the trial court system is keyed to the counties. Okay, and it is known as Superior Court. Oops, I think we already talked about this. I can't type. For the county of, you know, X, whatever it is. Okay, so the trial court is each county is its own trial court region. So we're right here in Orange County, right? That's us. Okay, so that's our first layer of the wedding cake. So if you want to do it like this, right? Okay, so that is our, right? We are Superior Court of Orange County. Okay, so that is our first layer, is Superior Court of Orange County. Our second layer specifically to us, and this is where the colors come into play, is this, you know, kind of light yellow color, and that matches with the 4th Appellate District. So when someone has an appeal from Orange County Superior Court, from trial court in Orange County, when they appeal, they'll be asking the 4th Appellate District to take the case, okay? So if you are working or have friends, you'll hear people sometimes refer to it as, I'm going to the 4th, oops, DCA, the 4th District Court of Appeals for California. So that is our system, okay? So they'll go to the 4th DCA. So if you're from Orange County, you're not going to appeal something into the 3rd Appellate District, because that's not the region it lies in. If it's Orange County, you're not going to appeal it to the 1st Appellate District. Again, that's not the region it's in. Now, obviously, if it's the Supreme Court of California, that covers the whole state, right? There's only one Supreme Court of California. Oops. Court of California. I love being able to type on these. So the Supreme Court of California is the final tier in this court system. So if you've made it to the Supreme Court of California for your state court case, that's the end. There's nowhere else to go. Questions on this? Does this make some sense to you? If you're feeling good, maybe put a 6 in the chat box. I can't remember if we did this already. If you have questions, then just, you know, unmute yourself or chat in your question. Oh, it looks like you guys are good. You guys are genius. You're awesome. Okay, lots of 6s. Yay. Okay, so I'm gonna clear these drawings. Nas like totally got it. Love it. Okay, maybe we did this already. I don't know. Oops. Okay, so then let's go to, so here is the same thing that we just considered, but on the United States court system or the federal court system map. So again, it's the same concept, but now it's the federal court system. So let me get my little annotations going here. Okay, so again, we are in California, and actually Orange County is in the Central District of California, C for Central. So what happens is, depending on demographics, right, you know, when you hear people talking about fill out the census, part of that weighs into this. Based on demographics and population size, will determine how many district trial courts, federal trial courts you get in your area. So California is very populous, so we have 4 district trial courts. And how do you know that? Anywhere you see these little hash marks on the maps, that means it's a trial court, right, separation. So California has 4 of them: Northern, Eastern, Central, Southern. Texas is quite large, so they've got 4, you know, and then states where you don't see anything like Utah or Arizona, that means the entire state region is one federal district trial court. There's going to be multiple courthouses, but it's one region. So here in the Central District of California, we're really lucky, right? When we can go places. There is a federal trial court in Santa Ana, right downtown there, next door to the Orange County Courthouse. There is a federal trial court in downtown LA, and then there's also one in Riverside, downtown Riverside. So super cool. We have a lot of 3 courthouses for Central District of California, okay? So again, when you have your trial court, ready? Let's see, where should I draw this so that it won't get too crazy? Maybe I'll do it over here, okay, boop. Okay, so again, trial court is known as district, Court for, Central District of California. And that might be hard to see. It might be cut off a little bit, but at any rate, that is our trial court region, okay? And I bet you guys, because you're super smart, can already figure this out. The appellate court region is, again, done by color. So we're the orange color, and we are in the Ninth Circuit Court of Appeals. So you can see it's like 1, 2, 3, 4. Where's the fifth? Where are you hiding from me? 5? I don't know. Are they like over here? 6, 7, 8, 9, 10, 11. And then we've got the DC Circuit and the Federal Circuit. So the country is just split into geographic regions. We in California, when we appeal our case, if we have a federal trial court, we will appeal it to the Ninth Circuit Court of Appeals. So if something comes out of Central District of California, that next level will be the Ninth Circuit Court of Appeals. You wouldn't have something come from Central District of California, but then go to the Third Circuit. That's not in the system, right? It goes up through the levels, okay? And then of course, the United States Supreme Court covers the whole region, okay? So our final court, if you're appealing something from what happened in the Ninth Circuit Court of Appeals, would be the Supreme Court of the United States, okay? And that's probably, so when the Supreme Court of the United States similarly makes a decision, it covers the whole country and everyone has to follow. But if you have a decision that came from the Eighth Circuit Court of Appeals, that washes over the whole Eighth Circuit, but the Fifth Circuit, does not have to follow what the Eighth Circuit does. So you will have what we call splits in the circuit or some differences. The Ninth Circuit might have a slightly different warrant requirement than the Second Circuit or than the Third Circuit. And so you'll have little differences. And then eventually, if those differences get big enough, they might go all the way to the Supreme Court of the United States and they will settle the standard. They'll kind of say, this is the one standard for the whole country. But sometimes, they kind of let the different regions do different things to kind of see how it's working out. So that can be interesting. Questions on this? Are you Gucci? Drop a 7 if you're good. Maybe we already did it. I don't know. If you have questions, drop a question. So drop a 7 if you're good. If not, drop your question. I'm seeing some 7s. They're a little slower. Maybe this feels a little more extreme. It's the exact same as really this map, right? It's just, this is the state system and the other one is the federal system, but it works the same way, right? And it's just really to help organization and it's kind of the idea too that the states near each other are similar and so they can have similar rules, things like that. I'm not so worried about standing, but let me go ahead and mention it briefly. So in order to sue someone, you have to have legal standing. And legal standing comes from really like this kind of two-part test. Are you the real party in interest? And did you suffer an injury? And what does that mean? It just means, are you the party who has the right to bring this legal claim? I was the one in the car accident. You hit my car versus my neighbor suing for me in the car accident. Like, well, wait a minute, neighbor. Like, you don't have the legal right to act for me, so you can't sue on my behalf. If I was a minor child and you were my parent, then you have the legal right to act for me, right? So you are the real party in interest for me, and the child suffered the injury. So it's just kind of to recognize that, which is not a hard concept. It's almost like so obvious. Like, of course, random people just can't sue for things that didn't happen to them. You know what I mean? Like, what are you doing? And it can't be a future injury. Like, I think 6 months from now, you're going to punch me in the face. I think next year, you're going to run me over. No, it has to be something that has either happened or is a present enough. So sometimes what you'll see is like, someone will file a court case to stop the freeway from being built, or to stop, like, think of the Dakota Access Pipeline, right? To stop the pipeline from being built. So it hasn't been built yet, but it's enough finalized that it's ready for us to file the lawsuit. It's not just like an idea in someone's brain. No, there's plans and they've had meetings and it's been approved, that kind of thing. So it can't be too futurific. Can't be too much in the future. Was this the class where we were talking about comic books? Word. And then on this issue of standing, I mentioned the Elk Grove versus Newdow case. It was from about 10, 11 years ago. And it was a case involving a girl, a child, in elementary school, I believe, here in California, where they say the Pledge of Allegiance. And I think it's pretty well known that you don't have to say the pledge. You can sit out from saying the pledge. But the dad said that wasn't enough, that he didn't even want his daughter to be in the room when the pledge was being said, or to have to listen to it because of the phrase "under God." And so he sued, and it went to federal trial district court, and then it went to the Ninth Circuit Court of Appeals. And what was really interesting was the Ninth Circuit Court of Appeals ruled that "under God" violated the First Amendment freedoms against religion, establishment of religion, things like that. And so it was huge legal news. Oh my gosh, it's on the money, it's on the pledge, it's, in the oaths of office. Holy cow, this is shocking. And it gets appealed to the Supreme Court of the United States. And it is big news. Oh my gosh, what's going to happen? We're finally going to get a word on what happens with this. So I've got a little, and again, it's just an audio clip because they don't do the video feeds. And what's really interesting, the dad was an attorney, or is an attorney. So he actually argued his own case before the Supreme Court. That's not always recommended, but interesting. So let me play this for a second. So you guys can, again, so getting another, version of that Supreme Court.
What do you make of the argument that in actual practice,
Uh-oh, I think I'm blowing the internet up at my house or something.
what do you make of the argument that in actual practice, the affirmation in the midst of this civic exercise as a religious affirmation is so tepid, so diluted, then so far, let's say, from a compulsory prayer, that in fact it should be, in effect, beneath the constitutional radar. It's sometimes, you know the phrase, the Rostow phrase, the ceremonial deism. What do you make of that argument, even assuming that, as I do, that there is some affirmation involved when the child says this as a technical matter?
I think that whole concept goes completely against the ideals underlying the Establishment Clause. We saw in Minersville v. Gobitis and West Virginia v. Barnett something that most people don't consider to be religious at all, to be of essential religious value to those Jehovah's Witnesses who objected. And for the government to come in and say, we've decided for you this is inconsequential or unimportant, is an arrogant pretension, said James Madison. He said in his memorial and
Well, I think the argument is not that the government is saying we are defining this as inconsequential for you. I think the argument is that simply the way we live and think and work in schools and in civic society in which the pledge is made, that whatever is distinctively religious as an affirmation is simply lost. It's not that the government is saying you've got to pretend that it's lost. The argument is that it is lost, that the religious as distinct from a civic content.
Heard the words, "God save the United States and this honorable court." Wouldn't the injury that you're complaining about be exactly the same? So you would have equal standing on your account of things to challenge that as you do to challenge what the school district does here?
I don't think the injury would be even close to the same. She's not being asked to stand up, place her hand on her heart, and say, I affirm this belief. And I think that can easily.
At any rate, so I just think this is interesting. You can go back and watch some of this. So the end result, I mean, everyone was watching this. What's going to happen? What's going to happen? We're finally going to get the ultimate word on under God. Is it good? Is it bad? And the Supreme Court came out with the decision. You know, it's like 150 pages long. Everyone's like, what? What happened was the Supreme Court said, we're not going to tell you the answer. We declined to find the answer because the dad lacks standing to sue. What? And it had gone through these other levels. And they said the dad lacks standing because mom and dad are divorced. They share physical custody, but mom has primary legal custody. So the mother, the ex-wife, has the legal right to stand in the daughter's stead, to sue for her. And not only is she not here, she didn't bring this lawsuit. She actively like thinks this is, you know, useless and pointless and ridiculous and is fine with it. So very interesting. So had the mom brought this, I know, plot twist, right? Totally. And it was, I can't even tell you this moment, like, you know, I mean, it may even be more than 10 years ago. I don't know, but it's still fairly recent. But I mean, it was a total plot twist. Like there were probably protesters out at the Supreme Court and all the news people. I mean, definitely the news was out there and it was big news. And then it's like, what? No, we want the answer. Tell us. So standing, really important, and it can rear its head at any moment, you know, so you never know. And then last couple little notes, venue. This is the physical location of the court case. So you've probably heard of this in terms of criminal cases the most, and you're going to hear more about it in the news, frankly. So you know which court system the case is in. You know who has jurisdiction, which we'll talk about more on Wednesday. Like, you know you're in the California state court system. You know you're in LA County, to use OJ as an example. And the proper courthouse based on where the crime happened and alleged and all this kind of stuff is the Beverly Hills courthouse, right? Because that was closest to the incident and that was where they lived. But he did a change of venue to move it to the downtown Los Angeles courthouse. So it's still within the LA County court system, still within the state of California, and that is allowed to do. So really, and it's more of a defense factor, you know, to consider. So yeah, sometimes with divorces, they'll try to, they'll move around different counties depending, and usually they still have to have some tie to that area. But yeah, you might think, oh, I'm gonna get a better judge over here or a better jury pool or different. So change of venue is something you hear about in the different systems, and that's just where do you wanna hold the case. So I definitely guarantee there's gonna be more of that in the news. So a few things to keep in mind at the end, because we're almost at the end. In some ways, anyone can file a lawsuit virtually over anything, right? Anyone can sue anybody, but they have to do it in the correct court, right? Based on the systems, which we'll talk a little more about one Wednesday. And once they file that lawsuit, though, anybody can file a trial court case, but it doesn't mean that you're going to get appellate or supreme, right? Those are much, much more specialized. And so I always have this funny little video that I like to play to remind you the Drake theory of court cases, which is you have to start at the bottom, okay? Hold on, I gotta pause my recording or else the thing won't like me when I share it.